So the next segment that we'll focus on is export control basics. And for that, we'll turn to my partner, Marco Gonzalez.
Thank you, Chris. Good morning, everyone. Understanding the basics of export control is always an essential component in becoming a federal contractor. Whether your business plan is to sell or export widgets to a foreign country, or whether you have a foreign national in your business, or you want to market to foreign entities, export control compliance is key. So, okay, just kidding. So I'm going to discuss some of the basic high-level topics that you should understand going into this. Needless to say, one can spend a whole week on the nuances regarding export control, but what I'm going to discuss are these topics right here, starting from, why we do this, why are there regulations and laws, and the most important part is to protect the country and for national security. I'm also going to discuss which government regulators have jurisdiction over export control compliance and the laws and regulations, which entities are subject to export compliance. Going to talk about the ITAR, which is the International Trade in Arms Regulations. That's the first step, the first scheme that should be understood in terms of export control, especially if you do plan to export munitions or military equipment and arms. And also the export administration regulations is key as well. That covers, and I'll go into that a little bit, about those items that have a military and a civil use as well, dual use type of items. And also the necessity to protect technical data and what that entails. So we're not talking about physical items now, we're talking about design specs and things of that nature. And obviously I'll go into some resources as well, so you can get more information on this topic. So national security is important for a host of reasons. And those of us here in the Northeast who went through 9/11 understand that combating terrorism is important. And so export control laws are there and regulations are there to combat terrorism. And we all know, given the last decade or so, the necessity to protect your business from, and also national secrets and national equipment and military from cybercrime and warfare. The support for sanctioned countries is an area also that, depending on whether there's an embargo, is part of the export control scheme. Human rights abuses, obviously WMD development, drug trafficking, and also competitive advantages. The United States wants to maintain a competitive advantage to other competing nations, and that's why we have these export control laws. So which are the players involved in the government side? So there's essentially three. The State Department has jurisdiction over compliance with regulations under the ITAR, and that pertains to inherent military technologies, and I'll get into that a little more detail later. The Commerce Department also has jurisdiction for those items that come within the EARs, the Export Administration Regulations, pertaining to dual use technologies. And also the Treasury Department's Office of Foreign Assets Control. Think about the monetization, the monetary transactions. The Treasury Department has jurisdiction over those type of transactions pertaining to persons or countries where there's sanctions, like Cuba, the export embargo to Cuba, or persons who are blocked or sanctioned, like the Cuban regime, certain people in Russia, etc. So those are the main agencies that have jurisdiction over the whole export control regime. So very important, who is subject to export control compliance? Well, US persons, and wherever they're located. And I'm not talking just natural persons, we're talking also persons created business entities that are persons also. Parties located in the United States, regardless of your nationality, are subject to United States export control laws. US origin goods, wherever they're located as well. Parties owned or controlled by US persons. So one of the things that I've done and I started getting into on the OFAC side of things was transactions that may touch upon Cuba or any entities with an interest in Cuba. And so the Department of Treasury can, with technology, just flag those transactions and just block them and seize those assets instantly before you know it. And a lot of it has to do with the ownership of some of these entities. And it's important that you know who you're doing business with and where your money's going to, because the US has jurisdiction over those transactions wherever they're located. And I'll go into that a little bit more. So what commodity jurisdiction? So which one of these agencies have jurisdiction over your export or your item or your technology? Well, virtually all items are controlled for export under the ITAR or the Export Administration regulations, but not both. And so when you start with the analysis, ITAR controls the export of items on a list that's called the U.S. munitions list, the USML. And I'm going to talk about that a little more detail later. If your item is not controlled under the U.S. munitions list, then you see if it comes under the EARs. And there's a list under the EARs called the CCL, and I'll describe what that is a little later. And virtually all items will either fall under the ITAR or the EARs. There are some exceptions. I'm not going to get into that now. That's kind of getting a little bit into the weeds. But the first level of understanding whether and which agency has jurisdiction and which regulations control the item that you wish to export will be under one of these two, virtually all of them. So how do you start the analysis? Two questions. First, is my item controlled under the ITAR? And if so, which category does it fall under the U.S. munitions list? And I'm going to go over the different categories. If the answer to that question is no, then you ask yourself, is it subject to the EARs? And if the answer is yes, because you know it's not under the USML, you need to determine which classification, the ECCN. And the ECCN is an exhaustive list of items, and they're classified. And I'll go over the classification organization in another slide. And the task is to try to fit your item under one of those classifications. And by doing so, you can tell whether the export of that item will need a license or not. Again, ITAR covers technologies that are inherently military in nature. I was in the Marine Corps. I served half of my time in infantry, so things like M16, M60 machine gun, grenades, mortars, those are things that are easily identifiable as military hardware and technology. Other things are not. It could be a valve that goes on an aircraft. It could be some hydraulic system that goes on a naval ship, but can also be used in a civilian uses. So things of that nature, it gets a little trickier to determine whether or not your item comes under ITAR or not. And so the list of the different munitions are available in the Code of Federal Regulations, 22 CFR 121. If you Google that, you'll see all of the different classifications under the U.S. munitions list. And also, I want to talk about technical data, because if your business plan does not entail the export of a physical item, but the transfer of data, you may still need an export license. So what does that mean? Things of design, blueprints, production, how-to information, manufacturing, testing, repair, all of that type of information, while not a physical widget per se, may come under the export control regime. So you need to know whether your item comes under that. And if you want to transfer or submit that information to a foreign person, most likely you're going to need to go over this review to determine whether you need a license. So what's on the USML? There's 21 categories here, ranging from firearms to explosives, surface vessels, ground vehicles, direct energy weapons, and also the catch-all Article 21. If it's not in the prior 20 articles, 21 would typically capture that. And each of these categories are very extensive in the list. And so the process entails you to go through these 21 articles to determine if your item comes under one of those. And if it doesn't, then you need to look at the EARs. Now, the government does have resources. If you don't have the expertise in-house, or you want to do some research before you hire a law firm like ourselves to do the analysis, for the ITAR, there's an online decision tool, and there's the link for that. And for the EARs, there's also a decision tool, and this is all free, and there's no sign up that's necessary, but you do need to do some research on making sure that you can answer the questions correctly in order to determine the order of review for under ITAR and the EARs. So if you've gone through the U.S. munitions list and you determine that your item or your technical data does not fall under there, then you need to look at the Export Administration regulations. And chances are your item may fall under that regime of regulations. And typically, those are items that may have a dual use, both in the civilian world and in the military world. And basically, there's this CCL list, commodity control list, where you're going to try to do the same type of analysis that you did with the USML and try to fit your item within that list. And so here's the CCL. So the Commerce Control List, when you go on the Department of Commerce website and you Google CCL, you're going to see a list over here on the left-hand side of 10 areas. And so your item, you'll need to fit that within a particular ECCN number, where you see that 3A001 as an example. And the way it's organized is the first number is one of these 10 commerce control categories, starting from nuclear and miscellaneous, and going down to category 9, aerospace and propulsion. So by knowing that first number, you can, direct yourself to where you have to go to find your ECCN number for your particular item. The second number, the second digit there is a letter, and it's either A, B, C, D, or E. And those are the 5 product groups. So once you've isolated and determined which control list category your product falls under, you go to the product group. And then that will again narrow down what your item falls under. And here I have an example, the ECCN number 3C002, which is item category 3, means electronics. Product group C means material, and it is a resist material and other substrates. And so for this example, let's say you've narrowed it down to 3C, and you look at 002, and you see this information here. It could be small, it could be a lot, but then the analysis turns on the reasons for control, and that determines whether or not you're going to need a license. So you've narrowed it down to this classification, and you're going to look at the reasons of control. In this example, it says NS and AT, and I'm temporarily going to go to the next slide. And so you're going to want to know, let's say you want to export this particular item to Australia. So you'll go down the list to the reasons for control for each country, and you could get that online to Australia. And our previous example, going back to the other slide, is NS column 2. So you're going to go to Australia, NS column 2, which is national security. There's no X there. So that means that you do not need a license for that purpose. So you'll go back to the ECCN number, and it's also controlled under AT, column 1. So you'll go back to Australia. Okay, AT is anti-terrorism, Australia, no X on the box. So that means you do not have to get a license to export this particular item to Australia. Now, if there's a country where one of these reasons for control are X'd out, that means you need a license. But the next step will be to see if there's an exception under the regulations. And each of those exceptions, regardless of what they are going to be in Part 740 of the regulations. And they could be very detailed. And you may make a business decision not to go through all of the conditions of that exception and just apply for a license. But that's something that you will work with your law firm or your export control officer to make that determination. So the process, so you've determined your classification, you've determined it's not on the USML, you made a determination that it's under the EARs, and you have your export control, your ECCN number for the particular item, and whether you do not need a license or you do. If you do need a license, the application process can be time consuming and can be a little complex, and that's where you may need help either by way of an export control officer or your law firm, your outside counsel that will help you through that process. Now, if you determine that in the example that I gave you before regarding Australia and that particular item that you do not need a license, then it'll be basically an EAR99 classification. That means you do not need a license to export that item. In the export papers, you will write down EAR99, so export control has that information and know that you do not need a license. But that's not the end of the story, folks, because the other things that you're going to need to do to make sure that you're fully in compliance with the export control regimes. And that concerns whether or not there are other elements. Basically, who's the person that's going to get this widget that's being exported to Australia? Is it the Australian Navy? Is it a private company? Who are the principals of that company? What's the name of that company? Are they on the denied persons list? Have they been debarred for fraud or for other things? Do they have connections to embargoed or sanctioned country? Iran, Sudan, Cuba. So Just because you've made the determination that there's no license required to export the particular item does not mean that the due diligence ends there. You need to determine whether the end use of the item or the end user are okay, and that they're not either on one of these denied persons lists, debarred, or if you determine that the end use, or maybe there's a circumstance where you think that they're misleading you, the government will look and conduct audits of all of your records when you do this analysis. So you need to keep records of your analysis for 5 years. And you're going to need to, in an audit, be able to justify the decisions you made in pursuing this analysis and determining whether or not you complied with all of the regulations, even if you do get a license. We had a situation recently pertaining to the export of a valve where we knew we needed a license, and it was going to a country for use in a nuclear power plant. And the problem there was we were getting conflicting information from the potential end user of the end use of the particular item, whether it was going to be used in the nuclear reactor core, in which a separate permit would have been required by the Nuclear Regulatory Commission, or whether they're going to be used somewhere outside of the nuclear reactor core, outside of that component, in which there would be no need for an NRC license. So it's important that you have qualified persons, experienced persons do this analysis for you so that you are fully in compliance with the ITAR, EARs, and all of the other end use and end user regulations to make sure that you're fully compliant with these regulations. Final word regarding technical data. Again, you need to go through the same analysis, even if it's not a particular physical item that you're exporting. You can do an export that's controlled by just emailing someone in your company in the US who's a foreign national. That's called a deemed export. So it's important that you understand whether or not any information that you're sending via email or overseas, it will be covered under the USML or the EAR. So it's important. And again, that's all types of technology, not just blueprint, but how-to information, repair, testing, maintenance, and the like. Okay, and that's my summary of this area. Thank you for your time.
Thank you very much, Marco. As you can tell, this material, when it comes to export controls, is an important area for anyone who's going to do international business in the especially when it comes to defense contracting.